Welcome to Healthcare du Jour, where we dish up and digest the latest in healthcare. For the next 30 minutes, sit back as we bring insight, commentary, and discussion on trending topics to the table, all expertly served up by our host and his guests. Healthcare du Jour is sponsored by SA Ignite, the law offices of Miracle Connell, and the Compliancy Group. And now here is your host, Matt Fisher.
Well, welcome to our initial episode, and a very special welcome to our first guest, Devin McGraw, who's the Deputy Director for Health Information Privacy at the Office for Civil Rights. As most people probably are very well aware, Devin is one of the primary HIPAA enforcers for the country. So, we're very honored to have Devin as our first guest. And, so Devin, thank you for joining today.
Thanks so much, Matt. It's kind of exciting to be the first guest ever on the first show. Thank you.
No, as I said, it's an honor. It's great to be able to launch with someone of your prestige, because obviously I know you're with OCR now, but clearly you had a very distinguished career before joining OCR.
Well, that's kind of you. I've been lucky.
Yeah, it's kind of nice when you kind of just be able to. Maybe, I guess, to some degree, maybe stumble in and get to pursue your passions when it comes to, and have your passions line up with your job.
Yeah. It's very fortunate that way. In that way, I think the opportunities that have come my way have allowed me to really focus on privacy and security issues, which, frankly, I started out in healthcare generally, so I don't know that I knew all along that this was my passion, but it sure has worked out that way.
Yeah, no, it's to some degree parallels what I've done. I've had a very broad-based practice. I'm at a kind of a small medium firm, and I'm the only really the primary healthcare attorney, so I get to work on anything. But I really have more of a passion at this point for the privacy and security. So actually, it's probably a nice way to transition. Kind of, I guess the first thing I wanted to talk about was to pick up on the privacy rule side of HIPAA. I think it feels like a lot of the enforcement actions that we saw would key in on security issues, but having heard you speak recently and seeing your writings, I believe that the privacy rule is a big concern for you.
Yeah, no, that's absolutely the case. I think for many people who get active in this field, it's the privacy issues involving, what are appropriate uses of health information, what should be allowed, what should require authorization or consent of the individual. I think sometimes those are the issues that kind of bring you in, and then you very quickly understand that whatever are the rules or the policies you develop to try to place some parameters around what are appropriate uses of information. You need the security controls and safeguards to make sure that those rules get honored, so that privacy and security often very much end up in tandem. And while it is the case that a lot of our high-impact cases, the ones that we've pursued within the last year or two to formal settlement involving corrective action plans and the payment of a monetary settlement, have involved security rule violations, it's not the case that all of them have. And in fact, two of our more recent settlements have really involved privacy rule issues. And the two that I'm talking about are the settlement with New York Presbyterian involving alleged violations of the HIPAA privacy rule, allowing a media crew to come into the hospital and to film patients without their authorization. That's a privacy rule violation. That involved a $2.2 million settlement and the execution of a corrective of a resolution agreement and corrective action plan. And then the other case involved sharing PHI with a business partner without executing a business associate agreement. And this is one that might be combined. This is private. This is really a privacy rule violation now that I think about it, because it involved ePHI. It was handing over X-rays, and which also had PHI on the sleeve of the X-ray, and again,
right.
not having a business associate agreement. So again, privacy rule issues implicated in both of those. It's also the case that any time we pursue liability around a breach where there's been an impermissible disclosure, that even though there may have been some security rule deficiencies that were also involved in the enforcement action, many times there is also an impermissible disclosure that occurred, and that disclosure is impermissible because under the privacy rule, the individual who was provided with access to the information was not authorized to have it.
Right. I think that's a good point, because it's, at least what I find when I read the settlements is, most of them were driven because there was a report of a breach, and then, obviously the New York Presbyterian one's a little bit of a different scenario, but it seems like there was a report of a breach, and then when you went in, or when OCR went in to investigate, then you were finding, broader issues. So it's not necessarily maybe the underlying cause of the particular breach, but the fact that that entity has become exposed to a further investigation that then reveals further problems.
Yes, no, that's exactly right. That has occurred in many of our formal settlement cases.
Right. And in terms of, kind of the privacy rule compliance, I think one of the biggest issues is, individual access to information. Certainly earlier this year, I know it was OCR and ONC kind of both put out guidance. Well, it was termed in many instances as new guidance, but I think at least from the legal community, we know it's kind of reiterating information that has always been there since the beginning about individual rights. So have you heard of any changes in behavior, or are you noticing any changes in behavior as a result of the reiterative guidance?
Well, so what we're noticing is that it's definitely coming to folks' attention, which is good, because we will hold people accountable for it. So it's good when they notice that we have guidance out there that explains what our regulations require. There have been, at least at this stage, a number of questions that have come in from entities, particularly membership-type organizations, who want to make sure that they can help their members comply with it. Questions, for example, about some of the clarifications around fees,
right.
Questions about scope of the designated record set, and we will, just so your listeners are aware, we will be posting additional FAQs as we get, questions that come in that make us realize that, well, maybe there still are some issues that we need to clarify. So we'll continue to do that. So keep an eye on our website, because that's where we'll post any new clarifications from time to time. But we also do hope that by the end of the year we can start looking at the volume of complaints that we're getting on individual access and start to see some decrease in those complaints. We historically have had complaints about individuals not being able to exercise their right of access. That's been one of our top 5 categories of complaints since really the inception of the privacy rules, and we'd like to see those numbers going down. That's not going to happen overnight. We recognize that, but we do hope that will be the case. In addition, as part of our audit program, which phase 2 has already begun, although we're still in the pre-audit phase, we have not selected auditees yet, but we have made it clear, and this is on our website as well, that as part of the audits, we are going to look at covered entities' compliance with our access provisions. So that should really give us, now that's not an enforcement tool, we're not using audit as an enforcement tool, but we are going to be looking at the audit to give us information on where we need to do additional guidance to help entities come into compliance, and what is the state of play out there for covered entities in different sectors and in different parts of the country in terms of how they are in compliance with our requirements in this area.
Right.
So I really do hope that we'll start to see over time a decrease in complaints that we're getting in this category. But I'm not. I do think that it will recognize that it's going to take some time for entities to start re-engineering their processes to make sure they're in compliance. It's a very big and important issue for the office. We do feel very strongly about it, and so we will continue to make it a priority in the coming years. And covered entities should realize that. Business associates, of course, have a role to play. They often hold the information that individuals may be requesting, and they have to cooperate and make sure that information is made available. And in some cases, if their business associate agreement requires them to, respond directly to covered entities, to individuals on behalf of covered entities, then they need to do that.
Yeah, and I find that the privacy side of it can sometimes be the more difficult one for the business associates to maybe fully comprehend. Because I think the security you can wrap your head around in terms of, that you obviously want to be securing the data or the PHI that you're holding on to, but those privacy ones, which are obviously driven a lot by the regulation, can be the ones where entities who aren't used to being in the healthcare field can get tripped up.
Well, I think that's true, and I think it's also, not all of the privacy rule obligations are going to be ones that business associates can be held directly accountable for complying with, and whether they need to pay attention to a privacy rule provision and to what extent is on some level going to depend on the scope of the work that they're doing for the covered entity and the terms of their business associate agreement, which may in some cases vary. Because a lot of entities put provisions into the business associate agreement beyond those that are per se required by the rules. So we recognize that this is not always an easy environment for business associates to navigate.
Yes. Yeah, and I wanted to kind of pick up on one piece of what you're talking about in terms of the access, which is that it makes up a large bulk of the complaints that you receive. So we were talking about the enforcement actions a little bit, and from previous comments from you that I've heard, it sounds like that a lot of the access complaints might be resolved kind of on the back end, between OCR and the entity that's the subject of the complaint. So I guess, is there any intention to get more public in terms of, imposition of fines or other resolutions, just so, sometimes it takes seeing the stick beyond the carrot to change behavior?
Right. Well, people sometimes forget that the very first civil monetary penalty that we ever issued was in part due to a failure by the entity to provide individuals with copies of their health information. That was the Signet case of several years ago. So we have gotten serious on this in the past. But it is often the case that where one individual complains about an inability to access their information, we can get that resolved much more quickly through a phone call to the covered entity to make sure that they understand what that individual's HIPAA rights are and that they're in compliance with it. But there also can be systemic failures to comply with those provisions over numbers of patients where the process itself for responding to individual requests is out of compliance with our rules, and we won't hesitate in those circumstances to use more of the enforcement tools at our disposal, including moving to a resolution agreement involving payment of a monetary settlement, and again, in a case involving, a systemic breakdown.
Right. I guess in terms of the systemic breakdown, if you get, or maybe the better question is, how often when you get individual complaints, does it seem like you're getting it from consistent entities, or is it that it is fairly broad-based, and then it's maybe just trying to wait until things aggregate to identify a systemic problem?
Well, so we do have a system where we log complaints. It's our program information management system. It's the system which holds all of our enforcement cases. It holds all of our data on breaches, and for a long time it was very hard to use that. You could use that system to try to search backwards to see if a complaint against an entity, if they've been complained about previously, but it wasn't always easy to do that. Sometimes when people file complaints against an entity, they don't consistently use the name of the same name for an entity. Oftentimes entities have multiple locations, and sometimes, again, when people file complaints, it's not always clear to us immediately or clear to our system that they're complaining against the same entity. But we've been working with our folks here who help us run that system to figure out what are ways that we can improve its ability to flag what's often been referred to as repeat offenders,
right?
Particularly around the same set of provisions. And so our capability to do that is improving. And on top of that, we do use our regional offices as our arm for investigation. And, they're the ones who have the most amount of familiarity with the covered entities and business associates that work in their area. And so when they see complaints that are forwarded to them, they're in a better position to be able to identify ones where there might be a systemic issue, and requiring further investigation. Yeah.
It kind of just seems like overall in healthcare, obviously big data and the analytics are hot topics. So
yeah.
It sounds like you're experimenting with that as well in terms of being able to better sort through all the information that you're receiving.
Yes. No, that's a good way to put it, Matt. It's a problem requiring a big data solution, and we're trying to manage our big data to figure it out.
Yeah, it just goes to show that no matter where you are in healthcare, you're being flooded with more and more data all the time, and it's how can you utilize it? Because clearly there's going to be value in it. It's just a matter of being able to transfer it from raw data into
actionable data,
into a usable format.
Yep. Yes, indeed.
So I'd hate to kind of do a little bit of a hard transition, but this kind of goes back to what you're talking about in terms of the access when you started to talk about the audits a little bit.
Yeah.
I was interested to hear that you said that it's not necessarily being viewed as an enforcement mechanism so much as a way for you to gather more information so you can provide better guidance and better work with the industry. So I guess what's your ideal vision in terms of the outcome from the audits?
Well, I'd like us to get a good cross-section of participants in the audit. I am, hopeful that we'll surface some best practices that we can highlight, as well as surfacing issues where we need to provide more guidance or work with industry a little more closely to try to resolve. I'm hopeful that we will see more entities doing security rule required risk assessments that cover their entire enterprise. That was a problem that was revealed in the phase 1 audit. We've tried to provide more tools on security risk assessments, and so I'm hopeful that we're going to see some better performance out there with respect to that issue. And then, we're going to be auditing business associates in this phase 2 of the audit for the first time. And from what I have been hearing from counsel, mostly attorneys who work closely with both covered entities and business associates, or more exclusively with covered entities, that this is an area that where we are going to see a lot as part of the audit with respect to business associates.
Yeah, actually, I have a question for you on the business associate side of it. Because I was actually meeting with a client this morning that is pretty much strictly a business associate, and they told me that they received an email from, it said it was from, I believe they said it was from OCR, and it was directed to the privacy officer asking to confirm if they were the appropriate contact information. So is that a type of email message that is going out already?
Yes. Yes.
Okay.
Yes.
Because it was actually the first one that I've heard of.
Confirm.
Yeah, they did. They said they confirmed the authenticity of the email.
Excellent.
But yeah, no, that's actually I think the first that I've heard of a business associate beginning to receive that contact verification.
Yeah, we don't have as many contacts for business associates in our database, but we do have some.
Yeah.
So clearly, your client is one of them. We're going to be using the covered entity auditees to enhance our database for business associates before we move to the phase of choosing auditees from the business associate population. So, your client, got the email. That's our verification of contact email, which is really the first step in the process. What your client will get next is a questionnaire that just asks for a little bit of additional information about who they are and what they do and who they serve and how big they are and where they are. And then after they provide that to us, it will probably be a while, a couple of months before they hear from us again, because that is the process that, covered entities are also going through, as well as the business associates for whom we had contact information. And we're going to be doing the desk audits of the covered entities first, or we'll be at least selecting the covered entity auditees first, and those entities will provide us with some additional contact information for business associates, because we need a much more robust pool for them before we start forming auditee pools and then choosing the business associates that we will audit.
Yeah,
so,
and that's really makes sense, because as you said, as one of your goals is you want to make sure you're getting a good representative cross-section of entities, so it makes sense to make sure that you've got a large enough pool to be getting your sample from.
That's right. I mean, we're not trying to require, a statistically significant accuracy in terms of our sampling, because we're not trying to draw off scientifically valid conclusions from our sample.
Right.
But we do want to be fair, and we want a good cross-section, and that requires us to have a decent-sized pool with some diversity in terms of type and size and geography, so that, again, the information that we're getting from the audit is helpful and not, slanted towards just one particular type of provider or one particular, or large health plans, or, we don't want it to leave out, ideally, an entire cross-section of entities. Business associates are so diverse in the type of services they can provide. That provides a bit more of a challenge for us. We may be doing more of forming of auditee pools based on size and less granular type. But we're just going to see when the data comes in how we're going to do that.
Right. And then I guess I'm sure we could talk about the audit process for days. I guess one kind of final question in the area, which is, even though I know you're saying it's not designed to be an enforcement process, do you expect that fines will come out of the audit process if you're finding deficiencies?
We don't expect fines to come out of the audit process. We did not issue any we're not going to fine people as part of the audits. We have an enforcement tool called a compliance review, which we can open up. We can open a compliance review for any particular reason, and we would not move an auditee into compliance rule status unless we saw some significant issues that we thought required immediate attention as part of the audit. So nobody moves from audit to fine, right?
Right.
You'd have to sort of have your status changed, essentially, from being someone that we're auditing to someone that we're doing a compliance review on, which of course we would tell you. But we don't foresee doing that. But we will not rule it out.
Right.
Because we want entities to.
If it's really bad, then it'll go over. Which
you
don't want to be in that. You don't want to be in that boat.
You don't want to be in that boat, and you also don't want to ignore us either, because we could also put you in that boat.
Right. Yeah.
Because you don't know why you're ignoring us, and we don't want you to ignore us. So.
Yeah, I think that's I'm sure you remember that from your days in the private sector. You always say never ignore the government. You might not. That is one thing that you cannot turn a blind eye to.
Yes. No. That. You may not feel ready for the audit, but really, I think the worst thing you can do is just hope that we'll go away and ignore us.
Yes. Yeah.
That's not advisable.
Yeah, no, that is definitely a way to go get into trouble.
Yeah.
So, I think we're starting to get close to the end of the show. So I kind of wanted to just, go a little bit broader in scope, and I think a lot of us know that you're still relatively new to OCR. So I just wanted to kind of get your thoughts and find out how it met with your expectations in terms of, I'm sure you were interacting with it a lot before you went inside. So did it meet with those expectations, or how did it differ once you got the inside view of things?
Well, every day is a little bit different here. I don't think I had a full appreciation for the workload on the staff here. It's considerable. I knew the staff was small. You really get a sense for just how small it is when you're here, and you sort of recognize the volume of the work and the magnitude of what we do. And I think I definitely underappreciated how hard working people are here. I've always had great relationships with the staff here as someone from the outside, but now that I'm on the inside and I see how hard they work, I'm even more impressed. We can manage to do a lot even with the small resources that we have. But I think my time on the outside was helpful too, because I know a little bit about what it feels like to, be very new to the HIPAA rules and just not have a really good idea how you even start to think about compliance.
Right.
Or even if you have some familiarity, just, navigating within the regulatory structure, which is very comprehensive, not always intuitive, very detailed in some respects.
Yes, that seems to be a very good point in terms of the healthcare, which is, oftentimes there is that concern that you have people in the regulatory role who, as you said, don't appreciate the full scope and the complexity that's there. So, I think that's a great observation to say that, you appreciate the ability that you had to have been working with these regulations before stepping into the role of the regulator.
Yeah. No, I think it helps. I hope that I will always be mindful of what it means for private sector entities who are really trying to comply and facing challenges from resource constraints to not just fully understanding the rules, and for as long as I'm here, I hope I always continue to appreciate that.
Yeah, no, I think that will be fantastic, and I think, certainly from my perspective, and hopefully other people reflected, it seems like there has been a lot of information and a lot of resources that have been coming out. That it seems like that's stepped up since you've joined OCR, and it seems like that it's being in conjunction with other branches of the government, whether it be ONC or the FTC with the mobile app tool that came out recently. So it's I think all these resources have been fantastic.
Good.
But I think again, thank you very much. Unfortunately, time has flown by extremely quickly, and our half hour has already run its course. But thank you again for being our first guest. Hopefully we'll be around long enough and we can have you on again, because this is a topic that is always of interest, especially to the health IT, to covered entities, to business associates, to everybody within the healthcare field. And then for everyone who's listening in between broadcasts, we can keep a conversation going on Twitter. If you've got the slides up, you can see my handle, which is Matt_R_Fisher. Devin's also on it at Health Privacy. And our hashtag is HCDEJURE. And you can also check out the calendar for upcoming shows on healthitanswers.net. But again, Devin, thank you very much for joining.
Thanks for having me, Matt. Anytime.